Local attorney Stephanie Brinkley has been helping families to grow and expand by navigating them due to legal challenges surrounding assisted reproduction technology and adoption. I talked one-on-one with Stephanie for this edition of Quintin's Close-Ups. And if you haven't already, subscribe to my YouTube channel and like Quintin's Close-Ups on Facebook. Stephanie Brinkley, welcome to Quintin's Close-Ups.
Thank you. I'm so glad to be here. I've been looking forward to this meeting for a while.
Oh, I appreciate it greatly. I know that since founding your own law firm, Brinkley Law Firm, in 2011, you have helped families grow and actually expand by navigating them due to legal challenges surrounding assisted reproduction technology, better known as ART, and adoption, which is why you actually are the new chair for the American Bar Association's Assisted Reproduction Technology Committee. Tell me, what got you from having your own law firm to now being the chair of this particular committee?
I'm one of the hardest working women in show business. That's what it is. I've actually been doing this for about 12 years. And, it's not easy to build your practice focusing solely on assisted reproduction. And I generally refer to it as fertility law because the technical term's a mouthful. So my practice first started out just doing everything that was family oriented, divorce and custody and all of that, while building up the fertility side of it, because it does cater to a certain segment of the community. It's expensive. Not everybody has the opportunity to build their family through a fertility clinic if they need to think outside the box. And that's exactly how I present it to my clients. My fertility clients, I'm the last person they want to see because I represent something in their journey. But what I want to represent to them is hope. Because if they're coming to me and we're building their family in an alternate fashion, their desire to be parents is so great, it's going to happen. If we have to will it into existence, that child is going to be here, and I will take them to the finish line, and I do it every single time.
And Stephanie, let me ask you, recently, how much have you how have you been able to will that into existence for some of those families?
Well, as a fertility attorney, my marketing is very different, okay? You have to remember, infertility and that journey is very private. It's very taboo. People don't talk about it in the open. It's only probably in the past 5 or 6 years with celebrities who have built their families through surrogacy and egg donation and been public about it, is it more commonplace to talk about this. So for me to find my clients, I have to go where they're going. Who are they talking to about this very private matter? And when they get to that point where they have to consider using third-party reproduction, the professionals they're talking to have their trust and provide them with their guidance. So I want those professionals to also trust me to continue to take very good care of their patients. So we have a great working relationship, and I make sure that I maintain that high caliber of service that they're getting from the clinic and from the medical professionals.
So Stephanie, for lack of a better word, I like to use this word a lot, but what exactly are your demographics when it comes to fertility law?
I typically find that my clients, probably within the age of 30 to 50, okay? Often they're professionals, working professionals. So often for the women, it's women like me who we did what our mothers told us to do. Don't rely on a man. Finish high school, go to college, get your undergraduate, maybe get a master's or a graduate degree and start your career before you start building your family. But the problem is that women, we often have underlying fertility issues that don't manifest themselves until we're ready to start a family. For example, I learned in my practice that you could be 25 years old and have the egg quality of a woman who's 35. So when you're 35, if you try to start having a family, then your eggs are not cooperating because your body thinks you're 45. And so it's not until you're in your career, you've checked all those boxes your mom told you to check, and then you start trying to have a family and your body's not cooperating. And that's when you need to go see a specialist to find out how to get back on track and what are your options.
And Stephanie, what are those other underlying, issues right now that you see that are actually associated with COVID?
With COVID, what I'm finding, it's been a really interesting journey. So I'll just focus on my families that are using surrogates to have a child. You know, when COVID first came out, all embryo transfers came to a screeching halt because that was an elective procedure. Okay, so embryo transfers were stopped for maybe 3 to 6 months. So everything, paused. Then as we move forward, initially intended parents, okay, and that's who created the embryo to be transferred. They did not want their surrogates getting a COVID vaccine. Everybody was scared of the vaccine. Okay, so initially that's what I saw. Then I saw, okay, we want her to get the COVID vaccine, but we want her to either do it before the embryo transfer or after the first trimester. Okay, because the first trimester is so important for baby's development. Now what I see is that they're kind of indifferent to it. If they would like for the surrogate to be vaccinated, but if she's not, instead they just want the surrogate to understand that if she contracts COVID during the pregnancy, they are not going to be responsible for the COVID-related medical bills because that is her personal choice. So it's really progressed and it keeps changing over time as the science improves, as an awareness about the vaccine and the benefits to it come to light. It's changed.
Speaking of expenses, Stephanie, let's talk about that. What are the expenses that normally are associated with fertility law?
Well, with fertility law for couples, first of all, they've got the medical expenses that are involved in working with the clinic. And depending on what kind of services you're receiving, it could probably, I don't know this for sure, I'm going to take a guess based on comments from my clients. It could be anywhere from, $10,000 to $35,000, depending on what kind of service you need. And then in the course of using a surrogate, you've got your medical expenses, but then you have to take care of the surrogate and her uncovered medical expenses. And you might even have to go ahead and buy an insurance policy for her. She's also entitled to reimbursement of her living expenses. So next thing you know, you go from, just the clinic fees. And if you have to go through a surrogacy journey, you could spend anywhere, I'd say from $75,000 to $125,000, depending on different factors. For example, if you find your surrogate with the assistance of a surrogacy agency, okay, an agency has their own fee. And depending on the size of the agency, that fee can be very modest or it can be very large. So there are a lot of variables that go into the overall budget. And when my clients first come to me to say, okay, our doctor said we should consider surrogacy, educate us on the pros and cons, what to look out for, what to expect, what's normal, what's not normal, what's reasonable, what's unreasonable, so that we don't go into this blind, because Google can be a blessing and a curse. I have a lot of clients who come to me very discouraged because they did their own research on Google and they feel defeated and overwhelmed, and that's why I have to help set them straight and give them hope.
Stephanie, speaking of that, what are the other trends that you and your office are currently looking at when it comes to that particular issue?
Can you restate that question?
Oh, I'm so sorry. When it comes to those expenses, what other things are you looking for as far as trends?
As far as trends, so remember I said that because of celebrities, surrogacy has become more popular and more talked about. Well, what I have found in my business, this is probably one of the number one things I advise my clients on. When you're looking to work with a surrogacy agency, there are surrogacy agencies and then there are surrogacy agencies, okay? And there are a lot of women who have been surrogates or egg donors before, and with the best of intentions believe because they have had a personal journey that they can run an agency. And so I'm seeing a lot of pop-up agencies, women working out of their home and running an agency. And again, while they have the best of intentions, they're not necessarily business-minded or medically minded. And so I encourage my clients, if you find an agency that seems attractive, please circle back to me. Let me do some research on the agency, because I will only want them working with someone who is credible and has been around for a while.
Absolutely. So when it comes to fertility law, Stephanie, what is the biggest difference from when you started your law firm to right now?
The biggest difference is couples who have embryos genetically screened. Science is a wonderful thing. And it's kind of like, 7, 8 years ago when flat screen TVs came out, and the first flat screen was about $6,000, and I thought, I'm never going to have a flat screen. Now I can get one for $450.
Right.
Okay, so I'd say 8 years ago, probably only 20% of my clients genetically screened their embryos for abnormalities that could pop up. Okay, because it was thousands of dollars per embryo. Now it's under $200. Okay, so now 80% of my clients have their embryos genetically screened because it's so cost effective. So that's probably the number one change I've seen, and it's definitely one for the better.
And what else is cost effective when it comes to that?
Cost effective. Let's see. I think doing their homework on the agencies, I talked about that. Remember, we talked about large agencies versus smaller. Large agencies will promise to match the parents within 30 days, and trust me, they will do it, but your surrogate could be in Idaho. Okay, so if you want to be part of the journey and have the option of going to a doctor's appointment, that's going to add on some travel expenses, and it makes the parties feel removed from the process. So that's one thing. And those larger agencies are able to match so quickly because they have a massive marketing budget to advertise across the country and recruit candidates. So you will pay more to the agency for their fee, but your timeline will be, will be expedited. All right. If you work with a regional agency to find a surrogate, then the agency fee is more reasonable, but you might have to wait 3 to 6 months for your match. And that's okay, because often there are things my clients have to do medically to get ready for the transfer. So the timelines kind of, they match up. Okay. So that's a nuance that I hope to meet with parents before they start their research so they understand the pros and cons between the two different size of agencies and where they're located.
And I hate to be redundant, Stephanie, but what exactly are those pros and cons now?
For the agencies,
Yes,
it's it's the marketing, their agency fee. Agency fee can be anywhere from $15,000 to, I've seen as high as $65,000 just for the agency. The timing of match, the larger agencies typically have a pool of candidates ready to go. They've already been medically and psychologically screened and they're ready. Okay. The regional agencies have a smaller marketing budget, have a smaller agency fee, and their candidate pool, it kind of trickles in spurts. So that's why it may take 3 to 6 months to match. Okay. And
oh, go for it. I'm sorry.
Okay. And I was just going to say, all agencies do a great job. It's a Cadillac service if you can work with one. They handle all the fine details, and they're with the parties throughout the journey. They make sure the surrogate goes to her doctor's appointments, make sure she's taking her vitamins, make sure the parents always feel a part of the process and are informed. So agencies have their place. It's just there's a cost, and considering that the medical services alone are high, adding all these additional expenses can be a bit cost prohibitive. And that's why my clients sometimes will try to match through social media, which is another avenue. But it can be done. If you have the guidance of a fertility attorney to help walk along with you in that journey, then you can do an independent match and find someone through social media.
Wow. And how much has that been as far as an uptick with social media in the past year or so?
I want to say probably 40% of my clients match through social media. Thankfully, they come to me on the front end and I will give them a list like, okay, here are your top 3 questions. Okay. And if they fail in any one of these questions, move on, because these are crucial to the match. And then sometimes, if they have the resources available, they'll say, you know what, it's too much of an emotional roller coaster to get excited about a woman and then she doesn't pass the medical screening or the psychological screening, and then we start at ground zero again. For our peace of mind, we'd rather pay an agency, and then that's when we have the discussion about working with agencies.
Wow. And I want to ask you this too, Stephanie, but what are the contemporary issues with assisted reproductive technology?
In South Carolina, the contemporary issues are that we don't have surrogacy statutes on the books. So that doesn't mean that it's illegal. It just means that our family court judges don't have a nice little checklist, things to look for. A, B, when you have a surrogacy arrangement, look for A, B, and C. They don't have that. But we do have some case law in South Carolina that deals with surrogacy, which is in our favor, acknowledging that agreements are valid and enforceable. So that's awesome. And then our judges are also applying the very high ethical standards of the American Society for Reproductive Medicine. ASRM, they make the rules for the clinics. So if the clinics are maintaining high ethical standards, of course, our judges want to apply that to just keep those standards high. In fact, the United States is regarded as having the highest ethical standards for surrogacy in the world, and we want to keep it that way.
And I know this might be a very touchy subject, but what are the concerns that you have heard from your clients about multiple births from ART?
A decade ago or 15 years ago, when doctors were I shouldn't say easily, they were able to be persuaded to transfer more than one embryo at a time. Okay. That was a concern. But remember, Octomom came out. Do you remember that years ago?
Yes.
Okay. After that, there was a complete shift in the medical community. Now, it's very rare to find a clinic who will transfer more than one embryo because they don't want a multiple birth. They want a single child to be born completely healthy, to be carried to full term, no preemies. So to have the best possible outcome for one child, they'll only agree to one embryo transfer. In a few cases I've seen after 2 or 3 failed transfers, they might yield and say, we'll transfer 2. One is a higher quality than the other. So the chances of both of them taking are not very high, but we'll go ahead and do it because the single transfer has not worked in the past. So let's just see if we get lucky.
Wow. And I hate to ask this question too, but is there an increased chance of birth defects if a woman is actually pregnant due ART?
Oh, no. Remember, I just told you,
Right.
80% of those embryos have already been pre-genetically screened. So the top, 100 birth defects that are most common, the embryos have already been screened for that. And if they do carry the gene for that defect, they're not going to be transferred. They're not going to be used. So that greatly reduces the likelihood of defects.
And how does the assisted reproductive technology actually contribute to society?
There's something that we're doing in society that's actually having a negative effect on a woman's fertility. I don't know if it's exposure to plastics, radiation. I don't know. There's some kind of society advancement that we have created that's having a negative impact on a woman's ability to reproduce. Okay. So assisted reproduction is offsetting whatever that is in the environment that's having a negative effect. I can't tell you how many women come to me, have been working with a clinic for years, have had multiple miscarriages. The doctors cannot pinpoint it, and it's classified as unexplained infertility. They never get an answer, okay? So rather than live with that unexplained infertility, because not knowing the source of the problem is just as frustrating as having the problem. So at least now with assisted reproduction, even if they don't know what's causing the problem, there's a workaround, okay? If your desire, and I tell my clients this all the time, if your desire is that strong to be a parent that you're sitting in my office talking about third-party reproduction, you were meant to be a parent and we're going to make it happen.
Is surrogacy legal everywhere in the United States? And if not, what states have the most favorable laws governing surrogacy and parentage?
All states now, Michigan was the holdout on surrogacy, but they just recently passed legislation approving surrogacy in their state. The most favorable states are California and Florida. They're more advanced. They have more clinics and they're more proactive in protecting a woman's right to use reproductive technology to have a family. So they have laws on the books that are very favorable for promoting families. And South Carolina is very family friendly. It's not that we don't encourage the use of assisted reproduction. As far as priorities go for the legislature, it's just not moved up the ladder to be addressed yet. South Carolina, we move at our own pace. That's just the way things roll here in the state.
And what should be included in a surrogacy agreement, that is?
In a surrogacy agreement, you want to make sure that both parties understand their rights and responsibilities. For the surrogate, you want to make sure that she's following doctor's orders all the way, from the beginning when the doctor says you've got to take certain medications to ready your body for an embryo transfer, when she's pregnant, all the things pregnant women normally have to do. Stay away from sushi, stay away from deli meats, don't go bungee jumping, don't go horseback riding, attend your doctor's appointments. Just take care of her body. And then for the intended parents, their role is to be an active participant in the pregnancy while at the same time respecting the modesty of the surrogate. In other words, you can go to the doctor's appointment and be a part of the process, but when things get personal, you need to leave the room and go into the lobby. Also, to be timely with compensation. If she has an uncovered medical bill, make sure that it gets paid promptly. We do not want our surrogates to have medical bills that go into collections because the parents were remiss in their duties. That would not be fair.
And what would happen if the surrogate changed her mind and asserted parental rights to the baby?
Would not be able to do that. Because she lacks a genetic connection to the child, she does not have legal rights. It's the DNA that wins the day. Okay, so that's why our family courts in South Carolina, they are looking for an affidavit from the doctor that verifies no genetic connection between the surrogate and the child. Okay, because that's what severs any legal rights.
And if a surrogate agreed to reduce the number of embryos in the case of multiples or undergo an abortion, should that become necessary for medical reasons, how could that person be sure that that the person will honor the agreement should the worst happen, I should say?
Surrogacy contracts make it very clear a surrogate's life always, always, always comes first. Okay, we would never ask a surrogate to jeopardize her own life just so another couple could have a child. That being said, in the case of a medical emergency, if a surrogate needed to reduce or terminate a pregnancy, obviously we're not asking her to break any laws. South Carolina's got a heartbeat ban that's in place. But surrogacy agreements, happen all over the country. So not just in South Carolina. So while not asking the surrogate to break any laws, if there was a need to protect her life because something ran afoul with the pregnancy, there's actually something called mirror syndrome. And I just learned this recently. Been doing this for 12 years. Just learned that a fetus can have a heart condition, and the mother or the surrogate's body will mimic that heart condition, which means if it's fatal to the baby, it could be fatal to the carrier. Okay. And so, if a surrogate for some reason, and I've met one or two surrogates who do not believe in termination, even to save their own life, which is shocking. And in that situation, if she decided, I know that I could die, but I'm not going to terminate, what's the consequence to the parents? Well, in surrogacy agreements, they typically agree to provide life insurance for the surrogate. In a worst case scenario, we always want to make sure that the surrogate's family is provided for, because a requirement to be a surrogate is that you've already had a child of your own. So we know she has a family and a husband, most likely, and we want to provide. So, a surrogate always has a right to bodily integrity, to make decisions about her own body. So for that reason, we always make sure that her family is provided for, heaven forbid.
And what should be included in an egg donor agreement, Stephanie?
An egg donor agreement, the key thing is an expression of intent. Now, this is in compliance with South Carolina law. When using assisted reproduction, there needs to be evidence of intent to create a life in being and to hold it out as your own. So if an egg donor is donating her eggs, we want a contract in the beginning that makes it clear she is making the donation and she has no intention to parent a child born from that donation. Likewise, the recipients are also signing that contract, making it clear they do intend to accept those eggs, create a life and being, hold that child out as their own, and parent that child. That is their expression of intent. So if you have a contract in place in the beginning, the courts will recognize parental rights and terminate the rights of the egg donor later if you bring a court action to affirm rights.
And in your mind, Stephanie, should an egg donor always remain anonymous?
I think it's impossible in 2022 to be anonymous. In the industry, they stopped using the word anonymous donation. Now it's called undisclosed donor. Okay, because with 23andMe and over-the-counter genetics tests, you can be anonymous for a while, but it's just a matter of time before your identity can be discovered. I'm not saying they will, but the ability to find a donor, it definitely exists.
So, okay, what if a child wants to contact her egg donor someday for personal or medical screening purposes? What then should be that particular approach?
Up until the child turns 18, there's typically language in a contract that says that the parents, the recipients, can reach back to the donor to secure medical information if it's necessary to treat the child. And I think that's just good for society, public policy. Beyond the age of 18, that child is an adult. So if they want to find their donor and ask questions, that's going to be a decision made between the adult child and the donor if they actually find each other.
And in addition to surrogacy and obviously donor agreements, what other legal arrangements do a person need to make sure as far as their baby and babies and actually have parental rights so that they're legally protected?
They need to bring something through the family court. For surrogacy, the default position is that if a woman gives birth to a child and she's married, she is the legal mother and her husband is the legal father. But, in 2022, we know that's not true. That kind of goes opposite to what science can do. So for surrogacy arrangements, we typically bring an action through the family court to recognize the intended parents, the creators of the embryo, and ask the court to issue a court order instructing that the intended parents actually go on the birth certificate, not the surrogate. Okay? Now, for couples that are using egg donation, often the woman who gives birth to the child doesn't really want to go through the process of filing a court action. But I often recommend it, and here's why. In South Carolina, we do not have a donor statute. A donor statute would automatically terminate the donor's rights once the donation is made. So since we don't have a statute, that means the only way you can effectively terminate a donor's rights is with a court order. Otherwise, those rights kind of linger out there, okay? So often I will find that unless the donor and the recipients all live in the same area, like the Low Country, where you run the risk of bumping into your donor at the grocery store, unless everyone lives in the same area, then they typically don't want to do something through the court. They're kind of like, we've spent so much money on the medical. Do we really want to take on more fees? But if everyone lives in the same community, then often they will take that extra step. It's especially important for the intended mothers because they don't want to be looking over their shoulders for the rest of their life.
And what is that parental establishment confirmation process or pre-birth order?
It's just petitioning the court, providing evidence to the court that there's no genetic connection between a surrogate and the child, providing sworn statements as to who are the parents and who are not the parents, and asking the court to recognize that, to bless it, and to make sure the birth certificate is properly issued.
And going on to another topic here, Stephanie, which is probably the last question I have, but what in your mind is the state of second parent adoption?
A second parent adoption, typically in third-party reproduction, it is an adoption by a non-genetic parent. Okay, so I'm going to give you an example. This is something we could probably spend another session on for my same-sex couples. Okay, so I have a same-sex couple, let's say a lesbian couple, they're married, but one spouse uses her own egg and her own body, and they use an anonymous sperm donor. Okay, now when that child is born, both mothers will go on the birth certificate, but Obergefell stands for marriage equality, not parental rights. So the non-genetic mother, her rights are subject to attack if they ever divorce. The genetic mother has the greater claim to the child. Okay? Now, these cases, divorces of same-sex couples and how to address custodial rights have been dealt with differently all over the country. So I tell my clients here in South Carolina, the best way to solidify your rights is to do a second parent adoption right after the child is born to make sure you are always recognized as the mothers of the child. Okay?
Stephanie, do you see an uptick in that situation here in South
Yes,
Carolina?
I do, because there's been a misunderstanding about what Obergefell stands for, and only with the publication of these cases, divorces and custody matters going awry, and inconsistent results across the country between the different family courts, is it coming to light that, maybe we need to take another step. So I'm getting a lot more consultations of couples saying, we had a child together 5 years ago. No one told us that we didn't have equal rights. What can we do now?
Wow. Wow. To be continued. Stephanie Brinkley with the Brinkley Law Firm. Thank you so much for your time. And again, welcome
Thanks,
to
Quintin.
Quintin's Close-Ups.
Thank you. Have a great day and a nice
Likewise.
holiday.
Likewise.